Okay, Ravinder ji, this meeting is now live on YouTube. Just sharing that YouTube link. So if somebody is not able to join, just tell them that they can join on YouTube at this
Okay,
moment, right?
Ravinder ji, this meeting is now live on YouTube. Just sharing that YouTube link. So if somebody is not able to join, just tell them that they can join on YouTube at this
Okay,
moment, right? Ravinder ji, this meeting.
Okay. Okay, I hope you have got that YouTube link. It's in the chat box. Okay. Just copy that. So if somebody is not able to join, friends, just circulate this. I will request even Parag Singhal and Namrata to just share this link in all the groups if somebody is not able to join, so they can join on the YouTube. Of course, they will not be able to participate in by speaking, but at least they will be able to see it. We'll sort out the other things later on. Okay, Parag, please do that. Okay.
Right, sir.
So sorry, friends, for this kind of disturbance. But anyhow, we were talking about mediation. Now, mediation is typically what is known as the conflict resolution. And this conflict resolution requires a collaborative approach. We have seen that if there is a dispute between two people, two parties, sometimes the egos fly like anything and the people are not able to even talk to each other. Now, if some third person comes in between, cools down the tempers, and then, of course, the discussion starts, because most of the problems can be solved by discussion only. This is known as conflict resolution, as we are aware. We already have certain laws in India, particularly we have arbitration. We used to have Arbitration Act of 1940 earlier, which was later changed to in 1996 to Arbitration and Conciliation Act. So two words came up, arbitration and conciliation. And now, of course, in 2023, we have Mediation Act of 2023. So friends, we have got three types of conflict resolutions. One is known as conciliation, second is known as mediation, and the third, everyone, all of us are aware, which we talk about the arbitration. What is the difference between these two? We will also talk about that. But let us try to understand the how you see the mediation can transform or reshape the future of the insolvency, because there have been a lot of discussions on mediation. People have been floating around the idea of mediation. So let me also share with you, friends, a lot of in webinars where I was invited to speak on mediation. I typically was of the view that the role of mediation in IBC is very limited. The reason why I'm saying this was because of very important reason. Because if you look at section 9 of the IBC, which everyone is aware, that the debt must be undisputed. If the debt is disputed, can NCLT admit application under section 9? The answer is no. It has to be undisputed. So if it is undisputed, where is the role of mediation? The role of a mediator starts when there is a dispute. Because please understand, when we are talking about conciliation, mediation, or arbitration, it presumes the pre-existence of a dispute. There has to be a dispute first. Otherwise, what you are going to resolve? So if the debt is undisputed, then where is the question of a mediation in that sense? So therefore, to a larger extent, that was not a good thing. Number two, now let me also share another part of it. So once an application is filed, should the NCLTs or the tribunals be burdened by the fact that they should be obliged to refer the matter to mediation first? Well, I was very clear on that opinion, which I'm very happy that IBBI has also agreed to a larger extent, that once the application is admitted, there is no role of mediation. Because the debt is undisputed, the matter has started under IBC, there is no question of going back. Of course, we have the provisions under Section 12A, settlement, all those things. Over a period of time, things have evolved and we have got used to it. That is all right. That is one part of it. But now, as far as mediation is concerned, what was happening, then a roundtable was organized by Triple IPI of ICI with some IBBI officials, and some IPs were also there. And I was asked to lead that discussion and make a presentation, where I also made a presentation. And I said that mediation is possible, but prior to admission under Section 9. So therefore, a provision must be brought that an operational creditor can start the proceedings under Section 9 only if he or she or it has tried mediation, just to reduce the burden of under IBC. If you think so, then you should put out a provision, come out with a provision where which it says first try mediation. If you fail, then you start Section 9, otherwise don't start. And even that can also be put in under Section 7. Why only restrict to Section 7 and 9 only? And a report of some recommendations were also submitted by Triple IPI. And I'm glad that one of the recommendations which talked about this, IBBI actually relied upon that and now came out with a discussion paper. So this is where we are going to discuss that. So let me share my presentation with you, friends. And then from there, we will first, what I'll try to do is I'll just present that discussion paper. What is the content of the discussion paper? And from there, we will move on to the a discussion part of it, right? So let me start with that. This discussion paper, my dear friends, if you look at this, this has been issued by IBBI on 4th November 2004. Now, this discussion paper, as IBBI says, it is number one, it is based on the expert report. It is based on the report which is submitted by the expert committee, which was formed for the purposes of framework for use of mediation under IBC 2016, and they submitted their report in January 2024. And after that, it was also complemented by Triple IPI ICI, which I just mentioned to you. They submitted their report, key recommendations for amendments in IBC 2016, with where there were 10 or 15 recommendations were given for modification, which is being considered by IBBI and MC at the moment. But in the meantime, they thought that whatever has been recommended in relation to mediation, let us put it out for discussion, and whether it is possible to bring it out in the form of a regulation or not. So mediation, what they have done is, it is only limited to only one single subject: mediation by operational creditors. We are not talking about financial creditors in this discussion paper. And before approaching the adjudicating authority for filing Section 9 application. So remember, friends, it is mediation prior to filing Section 9 application. We are not talking about mediation after Section 9, okay, or is admitted. So this is restricted to that particular extent. Now, what is the issue involved? I think the issue involved, which is mentioned in the discussion paper, I think most of us are aware that there are many common disputes which exist between the corporate debtors and the operational creditors. It could be in relation to quality of the goods. It could be any contractual dispute, amount which is payable or which is owed, or there could be somebody is talking about the set off or counter claims are always there. Some damages are being also claimed on a contract, isn't it? But if those issues come before NCLT, now supposing an operational creditor files an application, corporate debtor says, no, 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 this quality of goods was not right. And you see, and there is a Supreme Court judgment also which says that, of course, the debt has to be undisputed, and the NCLT can go into slight detail, not into a greater detail, but into slight detail to see that it is a genuine or a bona fide dispute, isn't it? So that was a judgment of Mobilox versus Kirusa Software, the second judgment by the Supreme Court under IBC. But this particular examination typically takes a lot of time, isn't it? A lot of time is consumed. Now, what we are trying to do is, in fact, in the discussion paper, it is also mentioned, and they have given us statistics also. It is very interesting to note that till 30th April 2024, total cases which have been filed under Section 9 are 21,466. But the cases which have been admitted by NCLT is 3,818, which is approximately 18%. It comes to 17.84%, but rounding it off 18%. So 82% of the cases have not been admitted. Why? There are numerous reasons, because they have been settled. Or some of them might have been rejected by NCLT, but that percentage is very less. But at the end of the day, most of them have been withdrawn because of the settlement. So the moment a demand notice comes, some matters get settled, but otherwise some matters get settled the moment Section 9 application is filed by the operational creditor. So this is another aspect which is there. Now, mediation as an option, can it be considered? The discussion paper says yes, because in any case, when you are settling today, even today also, when operational creditors are filing Section 9, and then there is a discussion of settlement goes on. And when we talk about settlement is what? Settlement is nothing but mediation only, isn't it? As a result of mediation, somebody has been able to settle it. But that consumes a lot of time of NCLT. So why not start the mediation and tell the operational creditors that please explore that possibility prior to filing of the application, so that once you have come to us and saying that, oh, mediation has failed, then that means now the debt is completely undisputed, isn't it? So therefore, that is the point which was which came around. Now, what is the proposal in the discussion paper, friends? The discussion paper says this is the proposal. Option of mediation to be provided to operational creditor prior to filing of application under Section 9. Friends, please note that word, option of mediation. It is not mandatory. It is voluntary. Option has been given to the operational creditor and CD to settle their disputes by starting the mediation prior to filing the Section 9 application. We'll also have a discussion on debate on this, whether it should be made mandatory or not, whether it can be made mandatory or not. But for now, let us understand what is the proposal. Number two, it says the mediation can happen with the aid of a mediator. There is a third person involved in that, isn't it? In mediation, friends, let us try to understand, because I also mentioned about conciliation, mediation, and arbitration. Let me give you a brief of what is the difference between all these three. Conciliation is typically when two parties sit on the table and try to resolve their problems. There is no third party involved. There is a dispute between A and B. Both are sitting across the table and trying to resolve their dispute. This is known as conciliation. Mediation, now there is a third party involved, because both the people are not able, they are not coming on the same table. So therefore, they are brought on the table, tempers are cooled down, and then they are advised that, okay, sort the problem out with the help of a mediator who is an experienced person. And the third is arbitration, where even the dispute, because in mediation, what is the problem? What the problem was? The problem was, supposing A and B enter into an agreement after mediation, but then supposing again A does not honor or B does not honor, there was no consequences, because it was not under the law. There were no consequences. So therefore, the disputes were still going on. And because people were backing out. After even signing the agreement, they were backing out, and there were no legal consequences to it. So therefore, then there were the government also promoted arbitration, saying that you must have arbitration clauses, because it has to be in writing, where one person, three person, five persons, they can be appointed as an arbitrator. And it is like A is presenting his case, B is also presenting his case and evidence before the arbitrator. We call it as arbitral tribunal. And then the arbitral tribunal decides. And once they pass an award, that becomes binding as per the Arbitration Act 1996. I think most of us are aware of that. So these were the finer, broad differences between conciliation, mediation, and arbitration. Now, so report of the mediator has to be filed along with section 9, if you have conducted the mediation, that there is a failure of mediation because the mediation was taken up, it has failed, there is no scope of settlement. So therefore, that report is also to be attached prior to admission under section 9. And it says that the discussion paper presumes that this will likely reduce the burden of the adjudicating authorities. And if those cases, like I showed you the statistics earlier, 21,000 cases filed, only 3,818 admitted. So 18,000 cases actually consumed the time, isn't it? So if that time becomes available, then I think the working of NCLT, efficiency of NCLT will improve, and they will be able to concentrate more on pending resolution plans and other pending applications, which we always feel that there is an infrastructure lacking of infrastructure. It is there. So this is one of the proposals, friends. Okay. Now let us look at what is now proposed to be done. Regulation 2BA is proposed to be inserted where? In CIRP regulations. Right, regulation 2B is already there. I think most of us are aware. So now they are trying to introduce 2BA, capital A. Now, what is the language of 2BA? Let us look at this. This is the language which has been proposed. An operational creditor may undergo mediation with the corporate debtor for resolving the disputes of commercial nature in accordance with the provisions of Mediation Act 2023 before filing application under Section 9 and thereafter file the application under Section 9 along with the report of the mediator. So what are the broad points, my dear friends, you see in this particular aspect, right? Number one, let us try to break down this. So in the language which I have just shown you, the use of the word is may in the beginning. Let me go back to that slide. Look at this. An operational creditor may. So the initial word they're proposing is may. So what does may indicate? So may clearly indicates that it is not mandatory, but it is optional for the operational creditor and the corporate debtor to explore the route of mediation. This is one point. Number two, and if you look at the language again very carefully, I'll again take you back to that slide. Okay, yeah, so here it is. It says for resolving disputes of commercial nature. Underline the word commercial nature, friends. So let us go come back to the next one. So disputes to be resolved must be of commercial nature. That means it must be a commercial dispute. This is what they are trying to say. So these are the two issues which are there, but there are three more points which we must note in this particular new proposed regulation. Mediation in accordance with Mediation Act of 2023. So mediation not under otherwise, but it has to be under Mediation Act of 2023. And if you are going for it, it must be done prior to filing of application under Section 9. And then if the mediation succeeds, if the mediation succeeds, that means the end of the matter. Naturally, nobody will file an application for under Section 9. But if the report of the mediator is to be filed because the mediation has failed, then the report will be filed. It will be attached along with Section 9 application saying that now the mediation has failed. Now the application can be has been filed because of the mediation has been failed. So these are the 5 broad points which are there in this particular proposed regulation. Now let us look at this. How effective would be this provision, friends? Can we answer this question straight away on the basis of this? I hope most of you have got a lot of opinions on this. But according to me, if you ask me, friends, unless we understand the provisions of the Mediation Act 2023, I don't think we'll be able to answer this question, isn't it? So therefore, what I have done is in next few slides, very broadly, I'm taking over, I'm explaining the provisions of mediation. So some of you might have read it also, but those who have not gone through it, I'm just taking up only key provisions. I'm not going into the details. This is not a session on Mediation Act 2023. But let us try to understand the broad points of Mediation Act before to answer this question and also have a debate whether this is successful or not, right? So just wait for some minutes. Let us look at the Mediation Act 2023. Then we will open discussion, and then you can ask questions. And in the meantime, if anything is coming to your mind, as far as this proposed amendment is concerned, just note it down, keep it in the chat box, and then we will have a discussion on that also. Now let us try to understand Mediation Act 2023. What does it say, Fritz? This act typically came on, I think it was notified on 16 September 2023. Now there is a preamble, just like we have a preamble in our IBC, there is also a preamble. The purpose of this act is to promote and facilitate mediation, especially institutional mediation, for resolution of disputes, commercial or otherwise. Remember this, friends. In the IBBI provision, the proposal, the word is commercial nature. But if we look at the Mediation Act, it is not restricting itself to the commercial disputes. It says disputes which are commercial or otherwise, right? Then enforce those mediated settlement agreements. Now, this is also one of the greater objectives of this act, because I told you earlier, if you enter into mediation without Mediation Act 2023, it did not have a legal force. You could not enforce it. Anyone can back out. I agree with you today, but tomorrow I can back out. But here, the point is that if you enter into a mediation under the Mediation Act, now the chances are that it will be enforced, because that is the purpose, so that nobody should be allowed to back out of that. So enforcement can be also be done, which is a good thing, right? There has to be some backing, otherwise it's a waste of time, isn't it? Then they say, let us also create a body which will register the mediators, just like we have IBBI, which is registering the IPs and valuers. So they are proposing to create, friends, another body which is known as Mediation Council of India, MCI. Okay, even Medical Council of India is also known as MCI, but anyhow, this will be named as Mediation Council of India. As far as my knowledge goes, friends, Mediation Council of India has not been created so far. It is still in the pipeline. And also they are saying, let us also encourage community mediation and online mediation. Also, they are focusing that it should also be an acceptable and cost-effective process, because parties can be present at different places. So a Mumbai party in dispute with Delhi party, say a dispute is of, say, 10 lakh rupees. Now, if they start meeting and traveling, they're spending more money. So rather, they should better meet on online and try to resolve those differences. What is the overview of this act is, it contains 65 sections, very small act. It's not a very big act. 11 chapters, 10 schedules, right? How many sections does IBC has? Well, on the face of it, everyone says 255, but if you count A, B, C, D, it is 282 nowadays, isn't it? And then we have got 3 parts, and every part has got different chapters. 5 parts are there, and there are a lot of chapters are there. And then we have 12 schedules in IBC, but in mediation, we have got 10 schedules, right? So this is the overview of Mediation Act. So let us look at this. Number one, friends, to what it is applicable. Remember this, it is applicable to mediations which are conducted in India alone. So remember this. So if can a mediation happen in Singapore and Indian law will be applicable? The answer is no. It has to happen in India. Whether it is done between a foreign party or an Indian party, that does not make a difference. But it has to happen in India, right? But now another point, which I think has not been answered in this law, is what happens to the online mediation then? Supposing some party is in, we are encouraging online. So then, of course, probably they are going to create certain rules, because it says online mediation will be treated as online mediation as may be prescribed. So naturally, they will prescribe certain rules, which will typically indicate that if one party is located in India, so probably even online mediation can also be treated as that mediation was conducted in India. Anyhow, or it could be whether the mediator was present in India or not. Now, number 2. First condition is mediation must be in India. The second condition is either of one of this. All parties in mediation reside or incorporated in India, or agreement provides for resolving of dispute under this act, there is a mediation agreement between the parties, assuming, or it can be considered as an international mediation, right? Uh, and one of the parties is either government or a government agency or government body or a government company, and the matter pertains to commercial dispute. So for government, it has to be a commercial dispute, not otherwise. And any other dispute which may be notified by the central government for government or other agencies, governmental agencies. So for government agencies, mediation under the Mediation Act has been restricted only for commercial dispute, but it is not restricted for other parties. So remember this. For other parties, it can be a commercial dispute, it can be some other dispute also, which can be resolved. But there is but take it with a pinch of salt, friends. There is a Schedule 1 which says mediation is not possible in the following areas. So it is a negative list is also given. Well, we all understand that in criminal matters, no mediation can take place. So therefore, those are excluded. Similarly, some matrimonial matters are also excluded. So therefore, there is a long list of negative, you see, things which are not for where the mediation is not possible, right? Now, discussion paper, as we have seen, uses the word commercial dispute, isn't it? Now, what do you mean by a commercial dispute? Because I'll show you that once again, but it clearly said that the dispute of a commercial nature. Now, what do you mean by that? That means it's a commercial dispute. What do you mean by commercial dispute? Commercial dispute, my dear friends, uh, has not been defined in IBC. If we go to mediation also, Mediation Act also, it also refers to that it is a dispute which is defined under Section 2(1) clause number C of the Commercial Courts Act 2015. So even Mediation Act does not define what is commercial dispute, but it is referring to in a circulatory manner to the Commercial Courts Act of 2015. I think my friends will recall, if those who are not lawyers, let me explain it to them, that the parties were supposed to file, you see, civil suit for any recovery. But then since there were certain commercial disputes were there, so they wanted a faster resolution. So commercial courts, the concept was evolved into 2015. Commercial Courts Act 2015 was brought in, where a lot of, you see, lawyers association also strike the work, isn't it? Because of certain limits and other thing. Earlier, it was more than 1 crore of rupees. So then it was brought down to 3 lakh of rupees. So that's a separate issue. But Commercial Courts Act was framed in 2015. And under that, the commercial dispute has been defined in Section 2, subsection 1, clause number C, which is typically definition section. If you go to that, my dear friends, it's such a long definition. 23 clauses are covered. 23 clauses. What do you mean by commercial dispute? Like if there is a dispute between, you see, a technology agreement, it is dispute between the commercial agreement and so forth. A lot of agreements have been defined. Not all, but many things have been defined. So it's a very long definition which has been given. So so remember this now, why I'm telling you this, which means if in the regulation 2BA, if the word commercial nature is used, that means it will have a reference to the Mediation Act. Mediation Act goes to Commercial Courts Act, and Commercial Courts Act definition of 2(1)C will be applicable then. So then the mediation will be restricted as per Section 2(1)C of Commercial Courts Act 2015. So now the question that arises is whether we should retain the word commercial nature in that regulation 2BA or not. That is one of the issues which we have to debate on this. Number two, if you look at Mediation Act, friends, it also talks about pre-litigation mediation in commercial disputes. Now, if we are restricting ourselves to commercial disputes only, then there is another section which is known as Section 12A, which is there in Commercial Courts Act 2015. Now, it talks about pre-litigation mediation. In fact, we are actually promoting this pre-litigation mediation. Before you start litigation, you must mediate that. Now, interestingly, if you look at Mediation Act of 2023, and if you go to Schedule 9, Even Schedule 9 has amended Section 12A of Commercial Codes Act. So it has changed certain language, it has changed certain timing also, right? Under Section 12A, if I have to tell you broadly, mediation is to be conducted by the authority or a mediation service provider. Now the new words are coming, isn't it? Mediation service provider. Now, who is a mediation service provider? Now, mediation service provider, my dear friends, is defined in Section 40 of the Mediation Act. So, Section 40 of the Mediation Act 2023 now defines the mediation service provider. Now, it includes number one, that any body or an organization which provides for the conduct of mediation under the Act and the rules, and that body has to be recognized by the legal services authority. Then an authority which is constituted under Legal Service Authorities Act, that is also a mediation service provider. Then the third one is a court annexed mediation center. Like all of us are aware that maximum number of high courts and district courts have mediation centers attached to them. So even that is also treated as a mediation service provider. Like Delhi High Court has got a Samadhan, which is a mediation center, and any other body which is notified by the central government. So these are the four provisions as far as the mediation service provider is concerned, right? And mediation service providers will actually in turn accredit the mediators for the conduct of mediation. So they will kind of empanel. They will say, okay, you are registered as a mediator. Now you can act as a mediator, and then you can provide those services. Under Section 12A of the Commercial Courts Act, the commercial disputes of over rupees 3 lakhs must undergo pre-litigation mediation. This is mandatory. So if you want to file a suit for recovery under commercial dispute, which is given under 21C, if the amount of dispute is more than 3 lakh of 3 lakhs or more, then first you must try pre-litigation mediation. And the mediation period is also restricted, friends. It is 120 days. It must be completed within 120 days. And then 60 days extension is also possible. So total period allowed for mediation is 180 days. Now, another question which will come, you may come to your mind. Supposing I go for mediation, operational creditor, and they go for 180 days, and the mediation is unsuccessful. Time has gone. Supposing your limitation of time expires within that period of 180 days, what will happen? So here there is a specific provision, friends, that in case the time is consumed in mediation, that time will be excluded from the limitation period. So that will not be counted. So I think that is very reasonable. So this is what it says. Time consumed in mediation, that is from the commencement date of mediation to the termination date, that period will be excluded, which is very normal and logical, isn't it? And what is the commencement date? So commencement date is also defined. We have to understand those things. If there is a mediation agreement between the parties, then when one party gives a notice for referring the matter to mediation, so date of notice will be treated as a start of commencement of the commencement of mediation. And if there is no mediation agreement, the date when the mediator either provides his consent or when the authority appoints a mediator, then the date of appointment of a mediator will be treated as the start of the mediation. So this will be the starting point. And ending, of course, is there can be two possible scenarios. Either the mediation is successful or unsuccessful. If it is successful, the date when it is when they sign the agreement, mediation settlement agreement. In fact, there is a new term which has been used, MSA. When they sign MSA, then the mediation ends. Or if it fails, then on failure, you see the mediator has to give a kind of a sign a letter, so it's saying that it has failed. So that letter will be become the part of that. Now the termination has been done, right? So mediated settlement agreement is binding, can be enforced under CPC. This is also one of the provisions. Mediated settlement agreements can also be challenged on specific grounds, on the grounds of being fraud or there was no locus and so many other things, right? So those grounds are also there. So they can also be challenged under the law. Naturally, somebody has got a right to challenge that also. And what happens to the fees of the mediator? Mediation Act says once the mediation starts, unless there is an agreement between the parties, the fees will be shared equally by both the parties. Supposing the mediator is charging, say, 50,000 rupees, so both the parties will bear 25,000 unless there is an agreement. Supposing CD says, I will bear the entire fees, then it is all right. And once you have started the mediation, can you come out of the mediation? The answer is yes. It is also provided in a Mediation Act. Opt-out option is also there. So you can always, one party can always write that, okay, I'm not ready to continue with the mediation. So it is not that once you have started, you are bound by it. But once you sign a mediation settlement agreement, then you are bound by it. So these are the broadly, my dear friends, the provisions of the Mediation Act. So I'm just stopping my presentation. Now let us try to discuss and debate that what should be the scope of that provision which was there. So what I'll do is I'll go back to the proposed, uh, yeah, this is the regulation 2BA which they are proposing to insert. Let us read it once again and then I will unshare this. An operational creditor may undergo mediation with the corporate debtor for resolving the disputes of commercial nature in accordance with the provisions of Mediation Act 2023 before filing application under Section 9 and thereafter file the application under Section 9 along with the report of the mediator. So this is the proposed point which is being put in, proposed to be added in the regulation, right? Let us now discuss and debate whether this is right in this format or whatever suggestions we are wanting is, do we want a change into this? I'm just stopping my presentation and we can have a discussion on this. Anybody who wants to comment on this before I give my recommendations, I would like to hear from the all the members because it's a freewheeling discussion. I just wanted to give you an overview, which I have already given. So let us try to look at whether we can strengthen this provision or in what shape, whether number one, whether this provision is required or not. That's first question. Two, if yes, in what
Yes,
format?
sir. Can we start? So this is a very much required because it is going to be very cost effective.
Okay.
And as you have rightly suggested that more than 80% cases, it is being settled out of the court before going to the NCLT. So NCLT is definitely a cost, is more and time consuming process. And
Okay.
more so, this concept was there in DRT when the DRT started. They have later on come out with the idea of Lok Adalat.
Okay.
So can we compare this with the Lok Adalat and DR of? Is there any similarity, sir, in the Lok Adalat
Okay,
and this
Lok
concept?
Adalat. Okay. I'll explain. See, Lok Adalat is a different format in the sense that once you have filed a dispute, supposing a case, right? There is a pendency of the case. If there is a case, then they say, why you are going ahead with the cases? Why can't you come to the Lok Adalat? Let us try to settle. So it is after filing of the case. Mediation, what we are talking about here is pre-litigation mediation. कि आप mediation litigation start करने से पहले you should come to that mediation. So there is a slight difference into that. But you are right, for the format is quite similar to each other. Now, friends,
One
one
of
more
my
thing.
queries there,
Yeah,
because
just a sec, ma'am. Just a sec, ma'am. Now, the first thing is, like Mr. Ravindra Chaturvedi said, mediation has to be there. So, does everyone agree, or anyone says no, mediation should not be there under IBC? I mean, first we will let us understand the on the concept as a
no,
concept.
sir.
Sir, mediation has
IBC,
to be there.
Okay.
But at the same time, if you look at India, they keep on creating different bodies. Why can't we have a less number of bodies? Otherwise, again, these bodies they become they are empowered by the government on paper. Otherwise, nothing happens.
No, see, the point is, like for valuers, for IPs, for chartered accountant, naturally you need a specialized body for medical counsel. So,
Yeah.
for
So
mediation,
sir,
therefore, just
sir,
listen to me, sir.
yeah.
Mediation is a separate profession altogether. Of course, it can be combined. An IP can also become a mediator. A chartered accountant can also become. A lawyer can also become. Anyone can be a mediator. There is no qualification attached to being a mediator. Even a person with an experience, a businessman who has an experience of 25 years, he can also mediate. What is the problem in that? So, but we need a body to regulate, isn't it? Like how the mediation should be conducted, whether it is in a legal format or not. I think bodies are
Yeah,
required, so not
sir,
object.
bodies are definitely required, but what we have experienced is that once different bodies are coming, I mean, you look at the Insolvency and Bankruptcy Board of India versus the judiciary. Again, there is a fight of supremacy. So, kitna ladte ladega? I mean, and there is no coordination between RBI, which is also a body. So therefore, it is we are failing. We are getting the things a wave of relationship getting so complex that we will not be able to move to a single set of solution, a simple solution.
Chalo, anyway, your
Tier
point.
T, SF. I mean, what is the need of SURFACE if you want to strengthen IBBI
Do
insolvency?
no, my
Yeah,
simple question to you is, let's conclude. Are you in favor of mediation or not? Number one. Forget about a body. Whether you
Sir,
are you in favor of
yeah,
I'm
mediation.
yes,
not in
yes.
favor.
Okay,
Yes.
okay, all right, okay.
Sir,
Chalo, great.
actually, if
Yes, ma'am.
if the case will be decided by the mediation, then go for the NCLT. Then I think this will be the disputed case. The
No, no,
disputed facts was will be there.
no. See, ma'am, let's
The,
understand.
the,
Let's understand. Let's understand. In mediation, supposing two parties enter into mediation, naturally everyone is going to present their own views, right? They will say this party did not do that, the other party did not do that. Now the question is that whatever you say in mediation, will it become a part of the record before the NCLT? The answer is no. This is what is, I did not include that in my presentation because my presentation was very limited. But Mediation Act is very clear. This says whatever you say in a mediation proceeding, that will not form part of the record. So
but
therefore,
the report we
no
have
report
required
will
to be
simply
filed.
no, ma'am. Let's understand. The report will simply say mediation has failed. It will not contain the facts of the case. It will not contain what was discussed. Because
Then, sir, what is the use?
it is just like outside the court, you're talking, but nothing comes on record. Nothing is coming on.
It's just like what we are doing in personal guarantee, little bit in a lighter version.
Correct, correct. It's like a without prejudice to whatever my rights are there in the law. So that is not a question which is going to come. So it is like outside the records. You are
Sir,
just
if sir, one more question is there. If I have filed the Section 9 application before the NCLT, before going to the mediation, I have filed the application first. But NCLT, I don't think NCLT will take up my application. If this law will be applicable, then the NCLT will give the order. First, you have to go to the mediation, then
no.
will come here.
Let's
Yes.
understand. I think I
Yeah.
probably have not been able to make myself clear. The proposal is not like this. The proposal is like this. That as an operational creditor, I will not be entitled to file under Section 9. You see, and there is of course, I will not say it is mandatory for them to explore because they have given an option. So there, the word which is used is may. So operational creditor, before filing under Section 9, has an option to start mediation, and if they fail, then he must attach the copy of that failed mediation along with Section 9. Then, in that case, supposing now the corporate debtor says, no, I would like to settle the dispute, then the NCLT will put its foot down and say, sorry, you have already explored mediation. I am not going to hear that. That's not my view. So that will not waste their time. Are you getting my point? This is the point
So,
which is there.
so,
Okay.
sir, withdrawal will not be applicable. It means ki we cannot withdraw the
I
application
don't I don't know.
after. Yeah.
It's, even 12A is still there, but they will not waste their time. They say, okay, we want to settle, and the NCLT says, okay, we'll give you 2 weeks time to settle. That will not happen. Now, only thing is, if the parties can still go and settle while the case is going on, right? OC files a case, notice is issued to the corporate debtor files his reply. That process is going on as smoothly as possible. No waste of time. But in the meantime, before the matter comes up and the parties say, okay, we settled the matter, then again under Section 12A, that settlement will take place. Settlement is not barred, but the time will not be given by NCLT now. They say, okay, if you wanted to mediate, you should have gone it before, not later. You want to settle, you settle it on your own, but we are not going to give you any time. हमारा process चलता रहेगा.
Sir, ऐसे भी अगर ऐसे भी if the operational creditor goes to the this.
Can I just interject? There are a lot of people who are waiting patiently and they have raised their hand. So can I take up their views first? Okay. So I think Parag Singhal has raised his hand. So Parag, please go ahead.
Sir, my basic question is, if it is not mandatory under IBC, why regulation is being framed?
Okay, good question. Good question. Good point. Okay, so mandatory, why it is part of regulation. Okay. Okay. You want me to answer it right now, or anyone would like to answer this? Because the answer is simple. The answer is, like, even under the Mediation Act of 2023, it is not mandatory. You get my point. Mediation is not mandatory. Now, there are two scenarios which has been covered under Mediation Act. Number one, both the parties, supposing, enter into a contract, and the contract, you see, contains a clause of a mediation, then naturally both the parties are bound. They will have to refer the matter to mediation first, isn't it? Like we have a clause of arbitration, so you have to explore.
Right.
So in many contractual, you would have seen, in fact, there was an international agreement which we were dealing. First, they talked about mediation. He said parties will settle across. Two, if the mediation fails, then the matter will go to arbitration, second stage. If the arbitration is also fails or does not happen, then of course suits can be filed and companies can go into the court. So mediation and arbitration both are always always voluntary. They are never mandatory. They can be made mandatory if it is forming part of the contract. Are you getting my point? So therefore, IBBI does not want to make it mandatory because Mediation Act does not make it mandatory. So how can IBBI make it mandatory? So therefore, it is in consonance with the Mediation Act. Now, the question you are asking is, then how effective it will be?
Yes, sir.
That is your question. That should be your question.
Yes, sir.
Okay. You said what is the benefit? So how effective it is? So that is one of the points, how effective it is. We'll discuss on that. Okay. Let's see the views of others in the meantime. I think we'll go one by one. First, Mr. Vikram Kumar, then Yatin ji, then Girish ji, then Vishwanath ji, and then of course we'll take up others. Or if somebody has written in the chat box, we can also consider that. Yes, Vikram ji, please go ahead.
So, yes, sir. So good evening, sir. Basically, two questions. Number one, how to become a mediator? How to become a mediator? If you want to become an insolvency professional, if an insolvency professional becomes a mediator, what is the process of becoming a mediator? Because that is a new profession going, a new opportunity being created. Number one.
Vikram ji, number one, we will talk about that, how to become a mediator. That will require a separate webinar and a lot of courses are being conducted and people are going for that. People do ask me question whether I should join that course or not. Well, according to me, there is no useful purpose at this moment. Don't spend your money because
you can track that question, sir.
I'll tell you because I'll tell you there has to be a mediation council. There has to be accredited mediators. Supposing you have done a training and that is not recognized by Mediation Council, then your money is wasted. So don't do that right now. That is what my advice. Okay.
So my main question is, sir, basically, as we know, if the dispute is genuine, then the application cannot be admitted. So if suppose an operational creditor files tries to go in for a mediation and the cooperator says that the dispute is genuine, then what is the incentive available to the CD to get into a mediation?
No, see, the point is this. As we have seen that trend, 82% cases have been settled. So therefore, there is a benefit in mediation. Let's not close our eyes. Out of 100 cases with the operational creditors, if 82 get settled outside the court, naturally by mediation or by arm twisting, whatever it is, I don't know. So therefore, there are ego problems. कई बार ऐसा होता है ना, सीडी बोलता है कि जो करना कर ले, मैं नहीं दे रहा पैसे. Now then then at the end of the day, sometimes they realize, oh, acha, we are going into insolvency, let's pay. So ऐसा नहीं होता boss कि dispute नहीं है, benefit नहीं है. The CD also gets a benefit because it is not going into insolvency.
I got your point, sir. My point is that the dispute is genuine or not is a issue of adjudication.
Sir, mediation में वो नहीं हो रहा ना. Let's understand, mediation is not trying to resolve the dispute in a legal way. It is simply saying, please come to the table and settle. Despite the fact there is a dispute between you, supposing A is claiming 80 lakh of rupees, B says, no, I will not pay you more than 40 lakhs. So 40 lakhs to undisputed है ना. Now the question is, we have to create a win-win situation as a mediator. उनको बोला यार, okay, with 60 lakhs. चलो दोनों की जान.
No doubt about it that opportunity is there. A big opportunity is there to resolve a lot of cases through mediation, not going to the NCLT.
Correct.
Absolutely.
See, they are not concerned. The IBBI is not concerned with that. Let's understand. The objective of IBBI is to reduce the burden of NCLT. What happens is people as an arm twisting tactics file Section 9 application, and then they say, okay, give us some time to mediate. वो आपने देखा है ना कितना time consume होता है. People and lawyers are coming, sir, give us time. So 6 months तक admission applications are pending.
But sir, what will be the process of initiating a mediation before filing an application? I think that is something which we still don't have.
No, that of course is there, but that is not for the IPs to consider. It is actually for the OCs and CDs to understand. And that will be done as per Mediation Act of 2023. So what we'll do is, good point, from IPNet, we will conduct a separate webinar on Mediation Act 2023 so that a great knowledge can, today I've given you only key provisions. I have not gone into the details. Okay.
Right.
I think we can organize that program. Okay, good point, sir.
Right. Thank you. Thank you.
Yeah, now Yatinji is there. Yes, he has been waiting very patiently. Thank you, sir. Go ahead.
So while I think you've already said that it is not a mandatory and optional, and you can't put it mandatory, but just again, like as you had also mentioned that when you really go for a commercial court, when you go to a commercial court, there it is mandatory if it is up to a certain limit.
Correct.
The point is, if you do not push it to some extent being mandatory and it is only optional, how is it really going to really impact the whole process in terms of timeline? Second, you also clarify that, okay, because today you have a normal approach where the NCLT will say, okay, you are trying to mediate and we'll give some more time. Well, my understanding is that is an inbuilt sort of a process that the NCLT has put in. If the NCLT has to progress, they should just progress in the manner, and if at any point of time it is settled, there is provision for withdrawing the application, whichever way it works. So how will that all change with the fact that mediation fails? They may, one is you say, okay, mediation failed. They may now say, okay, now we are not giving you time. But why can't they say, now we are not giving you time? You go and settle the matter. If it is settled within the permissible time and all this stuff, you withdraw the application. So the process of NCLT, NCLT has to change the mechanism. Why? How will mediation make it more time frame?
I'll tell you. Let me try to explain it once again. Today, what is happening is that as an arm twisting tactics, all OCs are filing Section 9, right?
Ashish sir, you're
I'm so sorry. I'm so sorry. Now, I hope now you can hear me. So what is happening is, under Section 9, those applications are being filed as arm twisting tactics. Once they file, what they do, then the corporate debtor and both of them say, sir, give us some time. So NCLT says, okay, we are not proceeding with the case. We are giving you 2 weeks time, 3 weeks time, 4 weeks time. So, and that is continuously given. So sometimes in many cases, I have seen even 6 months have been given to the parties to settle. So now what is happening is, a case is registered with the NCLT. It is pending on their docket. Their time, money and effort has been wasted because registry has spent their time. और उसको बार बार cause list में डालना पड़ता है और एक बार matter को hear करना पड़ता है. It takes 15-20 minutes to decide. So with that, those 15-20 minutes which are wasted in this, because they are not mediating themselves. They are simply deciding, oh, why do you need time, more time? So 15 minutes gone. Supposing 10 cases of like this in every day, 150 minutes gone. These 150 minutes could have been used for better things. So with this provision, today NCLT will say, you had the option of going of a pre-litigation mediation. Why didn't you do that? I'm not allowing you. But if you want to settle in between, because within 15 days you have to respond, there is a reply rejoinder, and we will be fixing the hearing for the arguments in the next month. Within this month, if you can go and settle outside without mediation, with mediation, we don't know. but we are not allowing you time. So आप ये समझे ना सर, ये benefit मिलेगा. So the time of the NCLT which is consumed in assuming that around, you see, 23,000 cases, imagine 23,000 cases multiplied by 10 minutes. Tell me, sir, how many minutes have been wasted of NCLT? So
Yeah.
I
So
think the
just
proposal is to save that time. That's the only intent.
no, no, sir, just to add on, and I won't take too long. I completely understand what you're saying, but the point again being this, sir, that unless either there should be some provision built into this thing saying that there no further time. I don't know whether it is possible legally or not, but there no further time is going to be permitted in case the mediation has failed and so on. Because unless this practice is inbuilt by the NCLT, it is today also they can inbuild this practice. It is not something which statutes say that, okay, we will give. I mean, this is a practice that is built in. If you say the practices of NCLT is going to change because they have said, oh, mediation has failed, and now they're going to say, without any law written, okay, now we're not going to give you time, fair enough. But then again, what I'm just trying to stress on is the NCLT mindset has to change how they
Right.
deal with the situation.
I don't deny that, sir. We are absolutely right. We are going to have a debate on the Supreme Court Jet Airways judgment in the next week on 16th November. Please be there. 2 former NCLT members are going to be there. We're going to debate on the efficacy and efficiency of NCLTs, right? Which the Supreme Court has very strongly commented. You are absolutely right. So mindset, what you use the word, and I'm catching that fancy. The mindset of NCLT benches have to change. They have to be educated. We need good people. We need people with domain knowledge, right? So this is still unwritten today, where it is written that they have to give time for settlement, but still they are giving time. But with this mediation thing coming in, I think they need to be educated that, look, pre-mediation provision was there. They did not explore that. Now you don't go into mediation part of it. I think you are absolutely right. They have to be educated. Good point, sir. Good point. So mindset has to change. That is one of the takeaways from today's discussion, as far as Mr. Yatin Sharma is concerned. Thank you. Okay, Girish ji, please go ahead. Thank you sir. Thank you for waiting patiently.
No problem. I always look forward to your seminars. Now the question is, how is the process going to be? I mean, this topic was raised by one of the earlier person who has asked the question. Because in family court, for example, there is a lawyer.
Hmm.
You know, the process is like, hello.
Yeah,
Hello, can you hear me?
Go ahead, sir.
Yeah.
May I request everyone to please mute themselves while someone is speaking? Yeah, thank you. Go ahead, sir.
So in family courts, the parties go to the lawyers, then they go to the court, and then court tells them that you should do the mediation. And if the mediation fails, then the next proceedings will start. So there is a court is actually directing them to go to the mediation. Now, in this case, who is going to do that?
Okay. Okay.
Is the IP going to play that role that they should? Because at the end of the day, there are two parties who are in fighting with each other. They need to be brought onto the table. On their own, they will not come to the table. Somebody has to be kind of tell them, look, you first sit on the table and discuss.
Okay.
So who is going to do that?
There are 2 things to it. Number 1, Mediation Act is also promulgating that you should start having a mediation clause in the agreement. Just like we have arbitration clause. So they say there has to be a mediation agreement, which can be either a separate agreement or common agreement with a mediation clause in it, right? So आज आपको क्या करना है, sir, as lawyers, as chartered accountants, as IPs, or any person who is advising the operational creditors or the companies, we must advise them that in your contract, you must have an inbuilt mediation clause. So if the mediation clause is there, then typically as per the act, as per the contract, it becomes mandatory. They will have to explore it. That is the first situation which is contemplated. The second situation is that even if the clause is not there, the parties can still voluntarily on mutual agreement, they can still enter into mediation. So what we need to do, as you said, somebody has to persuade. So according to me, not persuade, I mean, their consultants must persuade, number 1. Number 2, they must also be educated. So we must hold webinars for operational creditors that, look, this is a way this is an option which is available. Otherwise, if they are not aware of the fact, how will they come into mediation? So you are absolutely right. If as an IP you are advising some OCs prior to filing, then you can also advise them there is a mediation route available. Go to that route, explore that. Okay. And
Correct.
for commercial dispute, as I mentioned, under the Commercial Courts Act of 2015, any dispute more than 3 lakh of rupees, the parties have to undergo mandatorily a pre-litigation mediation before approaching the court. So commercial dispute mein to typically mandatory hai sir. Okay.
Right.
All right. Okay. I think now we can
Okay.
Mr. Vishwanath KS. Thank you, sir. Thank you for participating.
Yes.
Yes, Mr. Vishwanath.
Yeah. Good evening, all.
Good evening.
As I get to see, the objective is to reduce the burden on NCLT. One of the objectives, not necessarily the primary objective. So that being the case, if in the process of mediation, the aspect of a dispute comes in, why can't it be? It cannot be as of now as it exists because the documentation doesn't move on. There is no documentation that moves on to the NCLT. If there is an aspect of dispute comes in, and the objective is to reduce the burden on the NCLT, why can't it be carried forward and it helps decide that there is no case at all and it doesn't fall under Section 9?
No. See, the point is, sir, let us try to understand. I think we must understand the process of mediation. Mediation is not deciding the factum of a dispute. The dispute is existing primarily because I want to take money from you. You say, I will not pay you this much of money because there were defect in quality or goods or services, whatever it is. Another party says, no, it was not defective. Now the mediator is not deciding that dispute. Please understand that. That dispute has to be decided by any court. But today what we are saying is, why can't you sit down on a table and decide, yaar, finish karo, khatam karo na, why you are spending time on this? So if there was some defect in quality, sit down and try to sort it out and see, oh, okay, instead of 80 lakhs, do you wish to pay 60 lakhs? Is 60 lakh acceptable to you? So the point is, it is regardless of the dispute. So dispute ko to bhulna padega na, sir. If there is a fight between two brothers, to ladte raho, sir, court mein, to court will go on, proceedings will go on for 30 years, 40 years. So better it is settle down, sit down and settle. So nobody is settling the dispute. Nobody is settling, not deciding on the dispute. Whether dispute exists or does not exist, nobody is deciding on that. It is trying to reconcile between the two parties. Settle down.
Sir, if the arguments bear out that there is some contentions, why can't it be forwarded as it is to NCLT rather than start it afresh with NCLT again?
No. Sir, let us understand one thing. Please understand. If all those things are documented and presented to NCLT, then no application will be admitted under Section 9.
Okay.
Because what is there written in our law? Existence of dispute. There should not be any if there a dispute exists, then application cannot be admitted. So if you go to mediation and if it becomes an evidence of dispute, then I believe no application will be admitted under Section 9. So it has to be outside the records. The records are clean and clear. Whatever you say in a mediation proceeding, it is not brought on record at any point out. And it is written in the Mediation Act also, sir. That is the purpose. Otherwise, तो फिर तो dispute हो गया ना. फिर तो अब dispute नहीं भी हो रहा तो भी create हो गया. फिर तो कोई mediation में ही नहीं जाएगा. Nobody will come in mediation then. So that is.
Sir. Thank you.
Okay.
Thank you.
Yes, Mr. Modilal Pamecha ji, please go ahead.
Yeah, good evening, sir.
Good evening.
See, basically, what I visualize that mediation will be definitely helpful. See, now these days, what happens? These OCs, operational creditors, they are coming to NCLT, try to use the recovery mechanism. They don't have purpose to go for the true object of the IBC to have a resolution. They don't have any mind to go for the resolution. Sometimes these OCs are part of the promoter group. They want to file application to get the benefit, indirect benefit to these fraudster promoters. So definitely, if the mediation will be successful, provided the good infrastructure would be used, or mediation of center offices be provided, so that the common place would be provided along with the administrative support. So that involves huge cost also. But
Correct.
apart from that, if these kind of the promoters who are using the OCs to as a recovery mechanism, they should also be avoided. In addition to the reducing NCLT, maybe as a judicial mechanism.
Yeah, that is, you are absolutely right. That is a separate aspect where, see, whenever a law comes, there will be a use, there will be a misuse, isn't it? And all experts and consultants are much smarter. They are one step ahead of the lawmakers, isn't it? हमें loophole ढूंढने में ज़्यादा मजा आता है. I always say in a very, you see, interesting manner, where there is a loophole, there is a lawyer, isn't it? So I'm not criticizing any lawyer. I'm also a lawyer. It's only in a lighter vein I'm saying. So all I'm trying to say is this, that look, loopholes will always be there in law. Forget about that. Somebody is misusing it. The courts will take care of it, because if they are filing a mischievous application, NCLT has got powers to impose fine up to 10 lakh of rupees. ऐसा तो नहीं है कि नहीं किया, कई cases में किया भी है उन्होंने. So they have to find out and segregate. Somebody has to bring that notice that this is a collusive kind of an application. Regardless of that, we are talking about mediation in genuine cases. So out of 21,000 cases, sir, 17 have been settled, na? So
So I am in the favor of the having good administrative support to the mediation office, strong mediation with the administrative support. It can be definitely win-win for to all.
Correct. So I agree with you, and you also agree. Now, friends, let us discuss on this. Namrata ji, is there any comment in the chat box which needs to be considered besides this? Or anyone wants to speak before I show my last 2 slides of the presentation where I have given some recommendations? Should be
I
the
have
shape
two
of
questions.
regulation 2BA. I have also recommended. But anyway, I wanted to hear comments first. Yes.
Can we extend this mediation concept to the FC to the extent of 10 crore or MSME or pre-pack? Because definitely the concept is excellent and it can avoid and mitigate and will be most cost effective and reduce the burden of NCLTs. So,
Sir, first is, the question is, the point is, nobody is stopping even the financial creditors. So even if the IBC is silent on this, like Parag also mentioned, there are 2 points to it. If it is not mandatory, how can it be effective? That is number 1 question. I think that's a very important point. Number 2, then what is the meaning of putting it in IBC? Even if it is not written, people can still go in mediation under Mediation Act 2023. Mediation Act is already there. So nobody is stopping the financial creditors to enter into mediation. So therefore, these are very important questions which we must put in as a comment to the discussion paper, that why it has been brought out only for operational creditors and not for FCs. Number 2, why it has not been made mandatory. Number 3, if it is to be made, then it should be made for financial creditors also. But there is another point to it. Sir, even if I make it mandatory or optional for financial creditors, do you think SBI will mediate?
no.
So the point is that no banker will come for a mediation, because they will not say, okay, instead of 20 crore, you pay me 15 crore. वो तो OTS हो गया ना. With that OTS, they have got power of the board and other things. So nobody is going to come in mediation. वो तो OTS है ही ना. The RBI guidelines are already there for OTS. So you follow that guidelines.
So can we take a question first in the chat box, then we can proceed with the conclusion remark.
So one more thing, sir. Please allow me.
Yeah. Yes, Parag.
Sir, that means OCs will be better placed in mediation than in IBC, because in IBC, FC will take the major chunk of resolution plan, and OCs can get.
Naturally, because in the discussion paper also, Parag, they have rightly mentioned that most of the OCs are interested in claiming their money.
Yeah.
Typically, we have seen in a resolution plan what OCs get. They get nothing.
Nothing.
5%, 2%, 1%. इससे ज़्यादा तो नहीं मिलता ना. So therefore, it is always advisable. In fact, as a consultant, we must also advise all OCs to go for mediation, and जो मिलता है ले लो, better है.
ले लो. Right, sir.
That is much
right,
better.
sir.
Rather than
one small submission, sir.
Yeah.
See, as far as I am focusing on the word commercial, actually in IBC, the definition
right
by subclass 6, it goes for not only debt, even for the quality of the service, and sometimes it is for the breach of the any contract or representation.
Right,
So
right.
can it be, instead of being commercial, if we want to align with the definition of the IBC,
For
it can
all
be
dis-
simply dispute.
correct. In fact, Mr. Hari Prasad, I wanted to hear that because I know you are a lawyer. You have actually caught the eye. Commercial word has to be deleted. In fact, this is my recommendation in my slides also. I agree with you, sir. Why to restrict to commercial? Because commercial have got a very typical meaning. Under section 2(1)(c), there are 23 clauses which are mentioned. Why do we want to restrict only to that? And you are absolutely right. Breach of warranty, breach of representation is also a dispute, isn't it? So therefore, let it be a word dispute rather than commercial dispute. I fully agree with you, sir. I endorse that. Good point. Very good point. Yes. Anyone else would like to comment, or if we can take comments from the chat box, anyone can help me in doing that?
So
Namrata,
chat,
please. Chat box, most of the IPs and the members present are all in favor of the
Mediation.
mediation. Yes.
Okay.
And Mr. Swaroop has asked, can IP qualified as a mediator?
Absolutely, yes, absolutely, yes. But you see, the point is, let's wait. People are rushing into doing courses. Okay, of course, for your knowledge, if you want to gain something, do that courses. But will you be treated as a mediator after that? I'm not too sure about it because those authorities and institutes have not been authorized so far. They are not accredited. Whether they will be accredited, they will be accredited in future or not, I don't know.
So, I just for my knowledge, I don't know law much about it. I have been appointed by NCLT in one of the case as a mediator of the family dispute, and definitely the financial dispute only. It is the committee is headed by one High Court judge and one CLB member, and third is myself. So basically, there is no qualification as such, which I understand is required to become a
Yeah,
mediator, as you have rightly pointed out also.
absolutely, sir. Even a businessman with 30 years of experience is qualified, whether he's 12th pass or 8th pass. What does it matter? If he has a knowledge of commercial disputes, it is better. You don't have to
Yes.
be a technical person to solve that dispute. Anyone can become a mediator. But yes, I agree with that, that they must undergo some training also, because that training also tells them, exposes them to a Mediation Act provisions, because you need to know the provisions too. Mediation is also something like public relations, isn't it?
Right.
It does not involve the skill, it involves the skill of persuasion.
Yeah, communication, integrity,
Communication,
how you
correct,
can manage both the parties, that
correct.
is the things which is required for this.
सबका cup of tea नहीं है सर. कई लोग
Yeah, and you should have a very good grasping power to understand the problem and find the solution of both the parties.
and you should be patient to hear also.
Yeah, that is the first thing.
हाँ, अगर आप में hearing की patience नहीं है तो फिर आप mediator नहीं बन सकते. So
Correct.
we'll discuss about that, the opportunities in that area.
Sir, I have a query.
Yeah.
Now, the proposal says that in case there is a commercial dispute, we should go for mediation first and then come to the CIRP. As per CIRP regulations, under section 9, applications are not allowed when there is a dispute. Now, when mediation is failed, does it not mean that there is a dispute? And anyway, if there is a dispute, it is not allowed under CIRP.
Sandhya ma'am, this is what I have been explaining. Let me explain it once again. That is why whatever you discuss in mediation is off the records. Whether there is a dispute, whether it was tried to settle in mediation, it will not come off on the record. So therefore, nobody can claim tomorrow that, oh, there was a dispute in mediation, that is why we went for dispute, therefore you should not admit section 9 application. It is not like that.
But sir, now
Mediation provisions are completely confidential. No party can disclose, nobody can record, nobody can put it before NCLT or any court. And court will not recognize, this is given in Mediation Act, court will not recognize anything whatever is said in mediation proceedings. It is off the records.
Sir, but now the proposal itself says that when there is a commercial dispute.
So that is why we are deliberating on that point, whether the word dispute should be mentioned or not should be mentioned. That is what we are trying to do.
Okay.
Okay. In fact, this is
Sir,
my session also. I think one.
Sir, can I ask one small question?
Just a sec, sir. I think I saw one person who has raised a hand. I don't remember. Sir, if you can ask
Sir,
your question.
Mr. K.S. Ramesh.
Yeah, Mr. K.S. Ramesh. Mr. Ramesh, if you are hearing me, we'll give you the opportunity first because you raised your hand.
So
Okay.
kindly unmute yourself, Ramesh sir.
Okay, anyway, we can take up the other person. Yes, whosoever was wanting to speak, sir, please come.
Yes, sir.
Yeah.
Now, no, we are doing, we are discussing on the mediation, on the OCs, and it is also being misused for time buying and all those. Now, is it possible to redesign Section 53 or like that, where we can reserve a certain percentage for every stakeholder? Probably that might reduce some if they get something, at least the burden may be reduced, and every stakeholder may go at the end of the resolution plan or at the end of the liquidation.
So Ghosh, we have understood your point. Your point is relevant, very valid point, but it is unrelated to this part which we are discussing today. The reason is this: whether OCs should get certain percentage or not, then it is conflicting with the right of the secured creditors. Then why will they come under IBC? They'll say, okay, we will explore SARFAESI, we will get 100% of the money. Why should we share our money with the OCs? So even having said that, even in the key recommendations given by the committee of triple IPI ICI, we have also said that there should be a certain minimum guaranteed amount to OCs to be considered. Anyhow, government is considering that, but it is unrelated to mediation here. Idea in mediation is not to start IBC. You are saying Section 53 will come into play in liquidation. तो पूरा CIRP भी चल गया, वो liquidation भी चल गया. हम तो उसको ही avoid करने की बात कर रहे हैं. All right, okay. So now, friends, let's you see any other issue is there in Ravinderji before I show the last two slides.
Any question in chat box?
Not work domain is certainly. Mr. Abhiman saying specification of work domain is certainly useful, for which different institutions are needed for SOP for coordination. So no specific question as such. I think most of it is covered.
Okay, they are more or less the comments. Okay, all right. We'll consider those comments. Okay, let me show you now two very important. Yeah, I think Mr. Srinivas. Yeah, Mr. Srinivas, you want to say something?
Namaskaram, sir.
Namaskar.
Can mediator be appointed as an IRP? Person who has done mediation, can he be appointed as
no, sir,
IRP?
No, sir, because then there will be conflict of interest. That cannot be. That is
Thank
not.
You, sir.
That is not possible. Okay. Yeah, that's also a good point. So if you want to be appointed as an RP, don't be a mediator between those two parties. Okay, let's look at the two suggestions which I have given. I think if Mr. Hari Prasad is also hearing me, so I think, sir, we would like to have your comments, and anybody else's comment also is very relevant. Look at this. Removal of commercial dispute, as I think Mr. Hari Prasad also mentioned. File application only after failure. Now, if I take you back to the language, right? It is not very clear. I'll show you once again that language. Yeah, look at this. An operational creditor may undergo mediation with the corporate debtor for resolving the dispute of commercial nature in accordance with the provision of Mediation Act before filing under Section 9, and thereafter file the application under Section 9. Now, what does it mean? Supposing the mediation is successful, can he still also file? Idea is not that. So I think that this language should be redefined to say that if the mediation fails, then you should attach a copy of the letter or declaration or report of the mediator saying it has failed. Okay, so it has to be very specific. If it is successful, so now even if I read that language, even if the mediation is successful, it is still permitting the person to file Section 9. So I think that should not be the criteria. Okay. So let us go back to what I was suggesting, friends. Let us look at that. Let me show you that slide once again. So number one, removal of the commercial dispute, and it should also specifically say that application should be filed only after failure of mediation. So now what I have tried to do, my dear friends, is I have tried to rephrase or reframe or revise the language. I'm showing it to you on the screen now. This is the better language which I believe should be a part of Rule 2BA. Let us read it. An operational creditor may, before filing an application under Section 9 of the Code, undergo mediation with the corporate debtor. In fact, for the resolution of the disputes, I think that word should also be removed. I think one of our friends also mentioned that if we use the word dispute, that means it is now clear that there is a dispute. If there is a dispute, then how can Section 9 be admitted? So I think even that language has to be changed. Okay, I'll undo that also. So undergo mediation with the corporate debtor. I think I will restrict myself to this. For the resolution of the dispute, I will also remove it now. So let us read it once again. An operational creditor may, before filing the application under Section 9 of the Code, undergo mediation in accordance with the provisions of Mediation Act 2023. In the event of failure of such mediation, as evidenced by non-settlement report of the mediator under Section 21 of the Mediation Act 2023, or upon termination of mediation under clauses B, C, or D of Section 24 of the Mediation Act 2023, the operational creditor may file an application under Section 9 of the Code, accompanied by the non-settlement report or the record of termination or mediation as applicable. According to me, friends, this takes care of the provisions of Mediation Act also, and then it is more with a great clarity also. So it removes the word commercial. It in fact removes the word dispute altogether, because if we use the word dispute, which means if it is disputed, then Section 9 cannot be admitted. So we are taking it off the records. So this is my suggestion, friends, that the new shape of the Regulation 2BA should be like this. Anyone who would like to comment on this? Or
Sir, in case of partial success of mediation, in that scenario,
because there partial success may, then again the question is, there can't be a partial success, right? It has to be a complete success, because once you enter into a mediation settlement agreement, that means you have settled. You can't have a partial mediation settlement agreement. So I don't think, sir, there is anything which is known as partial settlement. And assuming, चलो आपकी बात भी मान लेते हैं, assuming there is a partial settlement, then the rest of the balance of the dispute should be more than 1 CR then. Okay. To come before the adjudicating authority. But according to me, there can't be any partial settlement. Okay. Anyone else who would like to, friends, contribute on this?
So there's a question from Mr. Pradeep Chauhan.
Okay.
So what about the moratorium on limitation period during mediation?
It is already there. I've already covered that. Mediation period.
120, 80 days.
Mediation period as per the Mediation Act is 120 days plus 60 days extension. So total period of 180 days is allowed. If you are not able to solve your mediation, settle the mediation case in 180 days, then mediation is automatically terminated in terms of Section 24. So, and if whatever time period you have consumed from the commencement of mediation till the termination of the Mediation Act says it will be not counted as the for the purposes of limitation law. Okay, I hope I'm clear on this.
Sir, okay. Mediation started before the initiation of this act, September 23. What will be the fate? Because that is going on since more than 1 year, in spite of the fact that it has been given a timeline.
See, the point is, you are talking about your case where you have been appointed as mediator.
Yes.
तो उसमें तो सर केस तो ऑलरेडी फाइल हो गया ना बिफोर द एनसीएलटी, फिर तो उसमें टाइम लिमिटेशन वाली तो कोई बात ही नहीं है ना.
Okay.
And see, if a court or tribunal, just also understand one more thing, friends. Court or tribunal has got power at any point of time to refer to mediation. वो तो Mediation Act में भी लिखा हुआ है.
Okay.
So if they refer, then it is a court governed mediation, ना court ordered, not court governed, court ordered mediation. तो court की तो कुछ भी power है सर, उसमें तो हम किसी को चैलेंज नहीं कर सकते ना court को.
Right.
Okay.
Sir, one more thing.
Yeah.
The time limitation provided in limitation, I mean, this Mediation Act, can we call it moratorium?
No, it is not moratorium. It is typically, चाहे moratorium बोलो, चाहे non-moratorium बोलो, but the idea is this period should be excluded from the calculation of limitation period.
For IBC purposes.
For any purposes, like supposing I go
Okay.
litigate, I want to file a civil suit. तो ये period तो
Okay.
निकलना चाहिए ना, नहीं तो civil suit में ये
Okay.
count तो मैं तो फिर file नहीं कर सकता. So whether it is IBC,
Okay. Okay.
whether it is suit, whether it is DRT, whether it is any damn thing. Okay.
Right.
Okay. Now I understand.
Right.
One question.
Yes,
Maybe
sir.
it's a very big question. Why is it limited to only operational creditor? Why can't, I mean, of course, if when a claim is filed, why can't the CD also look at the mediation before going to the next step? I mean, why restrict only to operational creditor?
No, it is simply saying, because you see, the point is, who is going to file a case? So we are not, right now, the case has not been filed. We are saying go into pre-litigation mediation. So CD cannot go into pre-litigation mediation. Naturally, the person who is willing to file the case against the CD, he will propose and say, okay, I want to start mediation with you. Are you ready? If it is a part of the agreement, it is mandatory. If it is not part of the agreement, then CD and OC both have to agree. One person unilaterally cannot start mediation. So both the parties will have to agree, sit for a mediation. If they say, okay, let us try to sort it out on a table. Okay, if they are able.
One more thing I would like to add here. Sorry to interrupt. That I came to know from some informal sources that few bench member has recommended to IBBI that section 10 should be scrapped because that is being misused rather than it is being used. So that recommendation is already under consideration.
No, sir, I will not agree to that because of a very simple reason. Then if they are agreeing for section 10 removal, that's not a good suggestion. Then, see, misuse does not mean that the provision is bad in law. You will have to curtail that misuse. Now, if there is a misuse, let them impose penalty of 10 lakh rupees. अपने आप लोग सीधे हो जाएंगे. So if you are scrapping section 10, then you'll have to scrap section 94 also. Then a personal guarantor debtor cannot also file on his own, then फिर तो 95 ही रहेगा. That was not the purpose. The purpose is, let's go back to BLRC. The purpose is not to punish a person. The person is facing a financial difficulty, whether it is corporate or individual. Let him go and resolve. Let him give him a chance to restructure his life. फाइनेंशियल डिफिकल्टी तो किसी के साथ भी आ सकती है सर. पर्पस ही डिफीट हो जाएगा अगर आप सेक्शन 10 को स्क्रैप कर देंगे. आई विल नॉट एग्री टू दैट सर. That's very radical, according to me. It should not be done. I think some people have recommended it without giving a thought. So it should not be done. Okay. Yeah.
Mr. Raju has put up, is it going to affect the reporting under Regulation 2BA if the mediator is not a professional, or it would be a general statement signed by any mediator?
No, see, the point is, now why I get muted, I don't know. Okay. Sorry, can you hear me now? Okay.
Yeah.
So see, the point is, let us try to understand, friends. Who can act as a mediator? Can anyone act as a mediator? The answer is yes or no, both. Why I'm saying so? You want to become a mediator, you have to become accredited. You want to remain in the panel, which is going to be maintained by Mediation Council or any authority or any accredited agency or mediation service provider. Let those things come. So no, there are no qualifications to become a mediator. Even a person with 8th class but having an experience in a particular field can also become a mediator. It's not that you need to be a chartered accountant or a lawyer or company secretary or a cost accountant or a banker to be a mediator. So that is one point. 2. So you have to be accredited. You have to be empaneled. Right now, there is no provision, but Mediation Act has come in. It has brought in those provisions. They have not been implemented so far. So let us wait for that time. So that is why I said, if you want to join any course for educational purposes to enhance your knowledge, to become a mediator, fine. But if you think that you have been certified, given a certificate to act as a mediator, I'm sorry, this is not going to help you at this stage. Don't waste your money for that purpose, because we don't know whether that institute or whether that thing will be accredited by the Mediation Council of India tomorrow or not. But for academic purposes, you want to enhance your knowledge, join any course. उसमें तो ठीक है. वो तो in fact, even transition is also going to start a small kind of a 2-day master class on mediation just to enhance knowledge. That's all. They are not giving any certificate that you can act as a mediator after this. But you must know what is Mediation Act, isn't it? And IPNet is also going to organize a webinar on this for 3 hours or 2 hours. We will do that. We'll do that. That is my only point which I wanted to mention. Okay, anything else or anyone wants to share? Or do they want any changes in the recommendation which we just suggested? Okay, I think.
Sir, sorry to disturb you, sir.
Yes, sir.
Sir, people are not, operational creditor and CD are not coming into agreement even in case of quantum of debt, that amount of debt itself. How can they come in agreement for appointment of mediator, sir?
No. See, that is why I said.
Unless somebody is enforcing forcefully, they won't listen in my view, sir.
No. That is not the point. Let's try to understand. I'll give you a small anecdote. In 1991, when I was acting as a chartered accountant, not as a lawyer, there was a party. I will not name that party. There was a dispute between the brothers. They had got 5-6 companies. Can you believe the disputes were going on in 26 courts all across India? Because they had a lot of businesses all pan India. And even at that time, I'm talking about 1991,
91. Okay.
So 26 cases were going on between the parties. They were spending money on lawyers like anything. In 1991, if you spent 5 lakh rupees per month, each party was spending. Can you believe the value of 5 lakhs in 1991? They were spending money like anything. Then somebody told them, I said, look, why you are giving, only lawyers are getting enriched. You are wasting your money. Why can't you come and settle? Ultimately, they realized the importance of mediation or settlement. So they went to the matter was pending in Supreme Court. Supreme Court appointed some mediator, and they settled the matter, and the matter was settled in 24 hours. Because now the businessman knew that they were just wasting their money. They can save their money. So kya hota hai, sir? You are absolutely right. Whenever there is a dispute, now the egos are very large nowadays. Nobody wants to come on. So therefore, that is why I said in the beginning, two things have to be done. Number one, operational creditors and corporate debtors have to be educated that there is no point in going into litigation. Number one. Number two, if the mediation clause, if we say you should always make it as a part of your agreement, then the mediation becomes mandatory. Are you getting my point? So whenever you are drafting commercial contracts, advise your clients to have a mediation clause. So if there is a mediation clause, then they will have to explore that route first. So whether they are willing to sit down or not, they will have to sit down together. वो क्या होता है सर mediation में, as Mr. Ravindra Chaturvedi is also there, I have also handled a lot of court appointed mediations. First, as a mediator, in the first 2 hearings, you just hear the parties. वो एक दूसरे को बहुत गाली देते हैं. हो गया, इसने ये किया, उसने ये किया, he did that. You have to be very patient. उनका पूरा जो whatever is there in their heart and mind, let it come out. उनको निकालने दो. बोल लो एक दूसरे के बारे में. जब वो बोल लेते हैं, then the mediator jumps in. So it is like a hearing more rather than speaking. So I think, so first we have to get to the idea of mediation, create knowledge about it, and then start working on it. Now, आप लोग एक क्वेश्चन नहीं पूछ रहे सर, अगर मीडिएशन ज्यादा सक्सेसफुल हो गई फिर आईबीसी के केस कम आएंगे? Are you not worried about that?
वो तो सर बोलता नहीं है सर.
होता नहीं है, because in any case out of 21,000, 18,000 have already been settled. तो ठीक है, it's part of business life, right? And if you are
कोर्ट में भी केसेस नहीं आता है सर.
नहीं सर, अच्छे केस आएंगे सर. If you do good work, work will definitely come.
Correct.
Oh, yes, sir. Quality cases will come, sir.
Quality cases. Actually, we want those cases. We don't want frivolous cases. Piece of IP is also not paid. आप देखिए, whenever the matters are settled,
yes, sir.
The piece of the IP is always in dispute, isn't it?
Yes, sir.
Nobody is willing to pay that. That is there.
Yes.
Okay.
I have a query here.
Yes, sir.
Now this international arbitration mediation centers are there now. Do you think that they have a role to play in this matter?
Naturally, sir, see, the point is, government is encouraging creation of mediation and arbitration centers, right? They are encouraging.
Yeah.
You can also do that with if you have deep pockets and you can organize that, so do that. But the only thing is, you should now be accredited as recognized as a mediation service provider under the Mediation Act and even under the arbitration also. So probably they will come out with some regulation that you should have minimum capital this, minimum facility this, XYZ, some requirements may be there. We don't know what is going to be there. So once that comes, if somebody has created that, that will be recognized and it has to be nationwide, right? Because mediation to be successful, Mr. Gulamadi, you will agree with me that there has to be a mediation center locally, isn't it? Now, a person who is into a rural area will not come to Chennai or Bangalore for mediation unless the mediation center is near to his business. So therefore, to set up mediation centers close to the business people, I think that is something which requires an effort.
At
So
least in a place where NCLT is established.
हाँ, but वो भी sir देखिए ना, I'll tell you one more thing. Today, NCLATs are at two places, one at Delhi and Chennai. Tell me how many people from Mumbai are not filing appeals because they will have to go to Delhi. The point is, it is too far for them or for Kolkata people. So why can't we have NCLT benches all over also, at least in major metros, there has to be there. So there are so many things to improve the efficiency of IBC and IBBI, and MCA has to really work on it. A lot of reports have been submitted. In fact, from IPNet also, we have submitted certain reports. I've been a part of many roundtable discussions with them. So I think some things are coming. Government is really looking for it. And I'm very happy with the judgment of Jet Airways, where 4 or 5 very strong words which have been used by the Supreme Court. I think they have not minced the words. We are going to have a discussion on that judgment, particularly on the efficacies and efficiencies of NCLTs and how to improve that. We are only targeting how to improve. We are not criticizing any NCLT member. We will only target how to improve. So we are planning to involve 2 members out of them. And we are going to have a discussion next week. Please block that date also. Okay. So friends, I think we have taken a lot of time today. If there are no more comments, I will request now Namrata to please take over and proceed for the closing remarks.
Yes, sir. Thank you so much for today, sir. This is your home turf. And we just like to thank you so much for the same. I'd like to ask Ravindra sir to please come in.
Sir, I have no word to express my gratitude and thanks to you, sir. Because of your guidance and initiative, we are just enlightening our knowledge and helping our IP fraternity that how we can keep updated ourselves, can resolve our problem, and we are just trying to bring all the IPs in one net, that so that all the problems of the IPs can be addressed and we can raise our voice. So I don't want to say anything because I don't have word either. If I start talking about you, I have because I'm one of the student of yours since like 2017. I almost attended all of your seminars since beginning. So I have a long list to praise you and thank you from bottom of my heart. And on behalf of all the members present here, I just again thank you very much for the guidance you have given. Thank you so much, sir.
Pleasure is all mine. Thank you for your kind words. Thank you.
Yes, thank you.
Okay. Now,
Thank you, sir.
yes, Namrata, I think you have to announce the next meeting and other things also.
Yes, sir.
Yeah.
So the next meeting is, as rightly Ashish sir has enlightened, that Jet Airways judgment in the last week, which is to be discussed in detail because the IBC has, the CIRB has run to the resolution plan has approved, and first installment was about to be paid, that was also forfeited. Lot of technicalities, and later on the Supreme Court has passed the order for liquidation. So whole exercise go waste, and it is serious concern, and we have to see if there is some lacuna in the NCLT working, or we are not criticizing, as rightly Ashish sir said. So we have to think, elaborate, and find out that where we went wrong and how it can be further strengthening the system. On that, we are arranging one seminar on 16th at the same time, because on weekly basis, the IPNet is keeping one seminar each, and the topic is enhancing the NCLT functioning insight from the Jet Airways judgment. That is the topic, and we will circulate the required intimation to all the members present. Now,
Thank you,
Namrata, please take over.
Thank you, sir. Now I request Ms. Bharati Daga to please give the vote of thanks.
Thank you, Namrata, for handing over me the mic. I am thankful to the IPNet for giving me the opportunity to deliver the vote of thanks. Today's event was not just another webinar. It felt like it was the beginning of something much bigger, with the Mediation Act coming in and I think the NCLT work getting reduced and we getting better cases than just the 12As and 30As. So the first and foremost, I would like to extend my heartfelt thanks to our dear speaker, Mr. Ashish Makija. Sir, we are really grateful to have you and listen to you. It was always a pleasure listening to you on any front, on any forum, anywhere. So your unwavering commitment and vision of IPNet are what makes this platform so special. As you shared your thoughts today, I felt reassured that we are on the right track under your able guidance. Thank you for being our guiding force and inspiring us to a bigger aim.
Great. I'm so thankful for your kind words. And I think we have created an IP not for few individuals, it is for all IPs. And we are creating resources over a period of time. So please continue to explore IPNet website. If you are not a member, please join it, become a member. And I think we can become a very solid force. And like today, whatever we have discussed, we are going to make our comments, give our comments to IBC, IBBI. And I think probably those will be considered. You will see that there are many changes which are coming into the proposed regulation, right? Thank you so much, friends. And I think over to you.
I would like to thank the technical team of Transition also, sir, for the great technical support throughout the seminar. It was really great. And
I think I must thank all IPNet members, particularly the regional heads like Mr. Ravindra Chaturvedi and everyone who is involved. Parag is also there. Namrata, I think she has been wonderful. She has been doing the anchoring of the programs for such a in a wonderful manner for last so many meetings. I think we must really appreciate and applaud.
Yes, sir. Namrata is one person whom we definitely have to applaud for her efforts during the meeting, organizing everything. I mean, it is too great.
Absolutely.
And thank you, Namrata, for doing it. Yeah.
Thank you so much, sir. Nothing without your support. Thank you so much.
Great.
And last but not the least, sir, the enthusiastic audience of ours.
Yes.
They were amazing. Without them, it wouldn't have been so interactive and so fun to hear everything, and a lot of questions coming in and a lot of suggestions going on. So I wish you that after the discussion, we are able to give fruitful information and our peace of mind to the mediation, that is the discussion paper which is on.
Absolutely.
Thank you very much, sir. Thank you so much for your kind guidance.
Pleasure is all mine. Thank you.
Looking forward to many more, sir.
Thank you.
Yes.
Thank you.
Everyone.
Thank you so much. Yeah. Thank you.
Thank you,
Thank you, sir.
everyone.
Thank you.